I'm Rebecca Markert, the Legal Director at Freedom from Religion Foundation.
And I'm Patrick Elliott, Senior Counsel at FFRF. As you can see, we're still under a safer at home order in Wisconsin. But despite these circumstances, we're hard at work because FFRF's mission to keep state and church separate is more important now than ever.
That's right. And today we're going to talk about our legal team and how hard they've been working to keep the wall of separation between state and church from crumbling. COVID-19 hasn't stopped our legal team from responding to state church threats. Later in our show, we're going to talk to Brendan Johnson, one of FFRF's legal fellows, about a case that was argued before the U.S. Supreme Court this week. We're also going to discuss some other recent important litigation developments.
So as always, if you have questions today, please feel free to submit those on our Facebook page in the comments or email askanatheist@ffrf.org.
So Patrick, you are the lead for our litigation team at the Freedom from Religion Foundation. And you guys have been really busy these last couple of weeks. COVID-19 really hasn't changed any of our deadlines. Most of our cases do not involve jury trials. There are very rarely any in-court appearances. Have you seen any impact on the pandemic in our work with respect to deadlines and filing and things like that?
Right. I mean, well, one impact has been, we're often suing the government. And so those lawyers have been very busy in terms of defending some of the COVID-19 litigation or in other matters. So we've had a few extensions in our cases, but otherwise they've been operating as normal. In fact, some things have picked up because we've wanted to weigh in on some cases where churches or religious individuals have been challenging stay-at-home orders because they say they should be able to break them because of religious reasons. And so we've been a little more involved in those cases, but nothing has really stopped, which is kind of surprising from the litigation standpoint.
And that is one case that I do want to talk to you about today. In Wisconsin, we are under a safer at home order. And last week, a couple of churches did sue the Wisconsin government over the safer at home order because they want to be able to gather and worship. Could you tell us a little bit about that case, Fabic versus Palm?
Yeah, and this was filed directly with the Wisconsin Supreme Court, or was petitioning the Wisconsin Supreme Court to take the case, and not only take the case, but also issue an injunction against Wisconsin's safer at home order. And so it was a pretty extraordinary remedy that the two individuals, so there's not actually churches involved in this case, but two individuals, one of whom was challenging restrictions on gathering size because he wants to participate in political gatherings, and the other person said that his church had limited gathering size to less than 10 people. And so we filed a brief on this case, on this petition last week with just a couple-day turnaround, basically pointing out that the state has a compelling reason in order to limit gathering sizes. We also were presenting information on a number of other places where we know that the virus had spread because of church gatherings, both in South Korea, in Sacramento, California. There's instances that have been traced in Kansas and a number of other states. And so the remedy that they were asking for, to strike down the safer at home order because this individual wants to attend large worship services, we felt the need to weigh in, and present that information to the Wisconsin Supreme Court.
And is it constitutional for the governor to prohibit large gatherings like that, including church services?
I mean, that's what's going to be decided by our Wisconsin Supreme Court, and maybe not just in the Fabic v. Palm case that we're talking about, but there is a prior case where they're just challenging generally the authority of the governor and the health secretary in Wisconsin to do that. But here, certainly, protecting lives is one of the most paramount interests of the state, and there's not, as some other courts have found, there's not a lot of other tools that the state could do other than limiting gathering size. And so, the legal test would then be, do you have a compelling interest, and are you using the least restrictive means? And so some other courts, a number of other courts have found, including in Illinois and in California, have found that, yes, this is constitutional. The issue presented here is under the Wisconsin Constitution, and so we've presented that the state should follow what these other states have done.
And what I found interesting about this case is the one plaintiff, Chapman, is a member of a church. He's not the leader of a church. So what he wants, he can't necessarily get. He wants the church to worship, but that's not really in his control. The leadership of the church decides if they're going to have those worship services. And we brought that up in our amicus brief, didn't we?
Right. It's an interesting issue because we've said, that this should be before a trial court to take a look at all the circumstances, because that's a huge problem. This individual doesn't control what the church does. And so there are a number of churches, and in fact, a group of religious organizations in Wisconsin filed a brief putting out a similar position as ours, that, that this is a safe thing to do, is to limit in-person worship sizes. Because it's a health issue. So we pointed out it's the same as, a film buff wanting the movie theater to open, or a Rolling Stones fan wanting to, attend a concert. It's really not within their control, even if they otherwise would attend those things. So I think that's the position he's in. He doesn't really have the proper stake in terms of challenging the overall order if he doesn't control whether the church is open or closed.
And our brief did catch the eye of opposing counsel, isn't that right?
Yeah, they did respond, quite lengthy response to some of the arguments that we had waived. And I'm glad that we filed our brief, because they were arguments, that the state and some of the other county officials were also being sued hadn't raised. So I'm glad that we were able to at least present those issues to the court.
Yeah, that's great. Do you know when this will be decided?
We don't know. I think the Wisconsin Supreme Court is going to issue a ruling pretty soon on the other case, generally challenging the authority of the governor and the health secretary to issue an order. That may resolve the case, or at least resolve some of the issues, but we don't know how soon the court could act on this.
And we've been very active in monitoring these types of cases around the country, as you alluded to earlier. Do we have any plans to file any other briefs in any other cases across the country on this specific issue?
Yeah, some viewers watching this are probably aware of cases in their state or neighboring states. We've been monitoring them, and we are planning on filing briefs making similar arguments here. One of those before the Ninth Circuit Court of Appeals right now is one that we would like to weigh in on, which is a huge, because of all the states that are within the Ninth Circuit, could have a major impact. So that's one that we're looking at. But certainly these issues are coming up again and again, and every week there's new cases, being filed. We've also participated in other religious liberty suits. So I think we have on the screen now one of our amicus briefs that we signed on to with Americans United, kind of on a coalition brief, also arguing about, how far does, claims of religious freedom go. That was on a contraceptives case. The case is Pennsylvania versus Trump. Some people may be familiar with this because it was argued last week before the U.S. Supreme Court. And so that's one that we weighed in on with a coalition of other groups, pointing out that, a company or a university's religious position, doesn't get to undermine the Affordable Care Act, which would require certain notice provisions if employers aren't going to be providing contraceptive coverage, so that the citizens in both New Jersey and in Pennsylvania, the states would have to pick up the slack and cover it, or deal with the ramifications of not covering it. And so that's another important case between religion and government that we've been involved in, and that the courts are looking at right now as we speak, both this week and last week.
Yeah, that case that you're referencing was argued last week at the U.S. Supreme Court. a lot of times we get questions about why we get involved in a lot of these reproductive rights types cases. Why would we be interested in a case involving the ACA, for example, and the provisions relating to contraceptive coverage? Can you tell our viewers a little bit why it's important for FFRF to be involved in these types of cases that touch on religious liberty in a sort of obscure way?
Right. Well, it's kind of a big question because I think there's a lot of reasons why it's important for civil rights organizations and people who support a secular government would weigh in. In reference to some of the litigation that's going on now, really people's religion is being used as an excuse to get out of the law. Everybody's religion becoming a law unto themselves. So an employer not wanting to provide coverage for both not only employees but their spouses or their dependent children, saying, no, my religion says you can't do this. And so it has obviously a health implications, and but it has religion implications. And what's the role of when there's a harm to a third party? Can somebody just say my religion says you can't do this, or can they ignore laws like the Affordable Care Act that would require certain types of insurance coverage? Part of what goes into that is it's not even just requiring coverage, but sometimes it's saying notice to either the government or to an insurer saying, I can't provide coverage, in which case then somebody else would take over. And so now religious groups are claiming even that would violate their religious liberty because they feel that they'd be complicit, even though they wouldn't be actually paying for or providing coverage, just giving notice. So I think these have huge implications for the role of religion, but also they're based in religion. Obviously, it'd be hard-pressed, at least in the United States, the history of trying to control women's health, whether it's abortion or contraceptives, is rooted in religion. There's just no way to avoid the rationale for why people aren't doing something or why there's been such a push against allowing women to control their bodies has been based on religion, at least in the U.S. and in the legal fights that have happened. So there's very good state church reasons to be involved in these cases.
And it is one of the reasons our founder, Ann Gaylor, and her daughter, Annie Laurie Gaylor, got active in this movement. So we have 10 attorneys at FFRF, and we restructured a little bit last year to really make room for more work in the litigation realm, including amicus briefs in courts across the country. And you guys have really done an amazing job at really ballooning that effort. How many amicus briefs have you guys filed this year or even in the last 6 months? Do you know? Do you remember?
I hope you know the answer because I don't know the answer. We've had in part, it's bad. It's usually bad news because if we're having to weigh in before the court, it means that there are cases where there's real state church separation issues at stake, either because of the establishment clause or because somebody's pushing free exercise in a way that we think is inappropriate. I know we've been involved with, let's say, 6 months. We've probably filed 5 briefs of our own and signed on to a number of others. So we've been more active than ever on informing courts about the issues that we think are important.
And it's really important to get FFRF's voice in before these courts. That is a big goal that we wanted to accomplish, and we really have been able to do that. Normally, we typically have submitted maybe 5 briefs per year, but you guys really have been prolific in signing on to briefs and drafting your own. So I feel that we were close to like 6 already within 6 months. And so when we do the calendar year count, I think we're going to be in the double digits. And that's a great thing. So thank you for that.
Well, you're welcome. It's a team. It's a team effort. Obviously, we have a lot of people putting in work at FFRF to get the job done.
So do we want to welcome our guest today, Brendan Johnson?
Hi, Rebecca.
Hi, welcome. So you are joining us from Montana. You are really socially distancing yourself from us. We wanted to talk to you today about a case that was argued at the U.S. Supreme Court just 2 days ago. So you worked on an amicus brief that we submitted in the case, Our Lady of Guadalupe versus Morrissey Baru and St. James v. Beale. They're two cases that were consolidated. These cases involve the ministerial exception. Can you talk a little bit about what that is for viewers who may not understand that terminology?
Yeah, the ministerial exception is a carve out from employment civil rights laws that the Supreme Court ruled was mandated by both the Establishment Clause and the Free Exercise Clause in a case in 2012 called Hosanna Tabor. It's a fairly straightforward principle in principle when it's applied correctly. Churches and other religious groups need the freedom to choose the person that leads them in order to freely exercise their religion, and the government must not intervene and force them to keep someone they don't want to keep without, and they can't do that without creating a great deal of state-church entanglement, which is where the Establishment Clause comes in. Essentially enforcing the civil rights laws, that is, preventing churches from firing their ministerial employees, by applying the civil rights protections that every other business in the country must recognize is the government action that is viewed as encroaching on religious rights here.
And so that's what was going on in, I mean, you don't have to go through the whole facts of the case, but that's what was going on in these two particular cases here, right? There were discrimination claims that the employees were bringing against church schools.
Yeah, that's right. So in Our Lady of Guadalupe, there was a teacher who had worked there for many years and alleged that she was fired because of her age, which she alleged in an age discrimination case, and that's the named case here. And in the Beale case, there was a teacher diagnosed with breast cancer who sought to get leave to get treatment. The school then fired her, and she brought a disability case against the school, but sadly died during litigation. And so the case is being continued by her husband. Basically, in both instances, the schools tried to claim that the teachers qualified as ministerial employees, and therefore they can be fired for any reason, discriminatory or otherwise, based on the ministerial exception. In both cases, the teachers had some minor religious duties that took a relatively small portion of their class time, but their main duties were teaching secular subjects, and neither considered herself a minister.
And so you filed, or we filed, with you being the primary author of a brief in this case. And one of the interesting things that I think we found, or you found when we were the concerns that we had were that, how broadly this could be expanded. If the idea of anybody who works for any affiliated religious organization could be a minister, then all the civil rights laws or employment protections, would go out the window. And I think one of the things that we highlighted was statements by religious right groups, Alliance Defending Freedom, putting out there and trying to tell religious organizations how to categorize their employees. And so here's one thing they said: when feasible, a religious organization should assign its employees duties that involve ministerial, teaching, or other spiritual qualifications, duties that directly further the religious mission. For example, if a church receptionist answers the phone, the job description might detail how the receptionist is required to answer basic questions about the church's faith, provide religious resources, or pray with callers. Consider requiring all employees to participate in devotional or prayer time, or to even lead these on occasion. And so it certainly seemed like, and they also go on, explaining the rationale. Employees with some duties usually performed by or associated with clergy are more likely to be viewed as minister-like by the courts. And so they're kind of giving away the ball game here for any religious organization, including what we're concerned about in part is religious hospitals, saying, hey, we'll give you a little bit of, requirements that maybe you have to answer a question about religion or say a prayer, and then now you're covered. We can never be sued for any violation of any employment protection laws or discrimination laws. I know that we pointed out, I don't know if you can talk about, the aspect of healthcare employees was one of our concerns, I think, that you wrote about in the brief, if you want to address that.
Yeah. So the reason this case is such a big deal and why it could apply to healthcare employees is that under the law as it stands, if before this case is decided, the courts are supposed to look at the totality of the circumstances to determine whether an employee counts as a minister. But the petitioners here, the schools, are asking the court to just look at whether an employee performs any religious function. And so that's why the quote that you just read, Patrick, just asking any employee to participate in devotional or any other religious function would, if the court rules in the petitioner's favor and adopts their test, it would essentially qualify any employee that is required to do any of these things as a religious minister, and therefore they would have no civil rights protections. And this matters for healthcare employees specifically because I don't quote me on the number, but I want to say 15% of hospitals in this country are Catholic, and the Order of Catholic Bishops has cooked into their healthcare directive admonitions for their employees to perform specific religious functions. For example, if there's no one else available, any employee at one of these hospitals may be asked to perform a valid baptism. And if that's not a religious function, I don't know what is. And if this applies to everybody, then literally any employee at any Catholic hospital could be fired for invidious reasons, like literally because of their race. And the hospital has an airtight defense of you're a ministerial employee, therefore you cannot sue us.
And so you and I both, right? You know, Brendan and I both, I know we both were listening live to the Supreme Court arguments because this is the first time I think that this has ever happened, that they've broadcast the audio live and did telephone hearings. So it was interesting to hear that. And we have some clips, and we kind of want to get your reaction, Brendan, to a few of these. And I think the difficulty is apparent from listening to some of the justices ask questions on how do we make these line drawing. And so we have I think Justice Sotomayor starts us off and talks about, I think, some of these issues in a pretty pertinent way to our conversation.
In your brief, you're encouraging us not just to define who's a minister by important religious function, but you're asking us to defer to the religious organization's determination of what's an important religious function. That's a recipe for saying the teacher who says a prayer at the beginning of a class, every teacher, whether it's a math teacher, a computer teacher, a gym teacher, they're doing an important religious function because all the school has to say is that's important to us.
Yeah, so here Justice Sotomayor is bringing up, again, one of the points that we highlighted in our brief, which is that the deference that the petitioners, the schools are looking for basically amounts to complete government acquiescence to a religious organization's desire not to be sued when they discriminate against their employees. In our brief, the way we put it is when a party against whom a rule is enforced decides when the rule is enforced, there is no rule. So basically, this would be a massive expansion of government deference to religious organizations.
Right, and we know, I mean, just in practice, just from family and from having, even people attending religious hospitals, that the employees oftentimes are not of the religion that the hospital is. So it just sounds bizarre in the first place to call them ministers of the religion when they're not of that religion. And so I think what we raised and what Justice Sotomayor is kind of concerned about is if the employer is the only person that matters, they get to just say, yeah, you're a minister. That would really be only to their advantage in every single case, and they could just use it, to the detriment of employees every single instance that they want. So obviously that doesn't seem workable. We had, other justices kind of press this issue and have to get at how do they, draw the line. And so we've got a clip from Justice Kagan asking about various kind of hypotheticals to counsel.
Mr. Rosbach, I have a too long list of hypotheticals.
So I'm hoping that you can answer them in just a few words, like basically, yes, he qualifies, no, he doesn't qualify. So here's the first one. A math teacher who is told to teach something about Judaism for 10 minutes a week.
And if he's teaching it devotionally,
that's all you know about him.
That's all I know about him. Then I would say probably not, because it would be de minimis.
A math teacher who comes in, and you mentioned the Shema at the beginning of your remarks. A very important pair, takes about 20 seconds to say. A math teacher who was told to begin every class with leading the Shema.
I don't think that is likely to fall within it, because I think it would again be de minimis under the Davis.
A math teacher who is told to embody Jewish values and infuse instruction with Jewish values.
If it's that alone, probably not, but it really depends on how that cashes out in actual practice.
I really am asking these things alone. A nurse at a Catholic hospital who prays with sick patients and is told otherwise to tend to their religious needs.
I think a nurse doing that kind of counseling and prayer may well fall within the exception.
Right. So here we hear Justice Kagan wrestling with one of the most serious issues in this case, which is that the schools are arguing that the tests that they're offering, like just look to whether or not an employee is performing a religious function. They're arguing that this will be an easier test for courts to apply that will result in fewer arbitrary decisions by the lower courts. But as you can see, just from a brief questioning by Justice Kagan, there's already a huge issue with line drawing. These are going to be, our decisions will be more arbitrary than ever. And even towards the end, the counsel admits one of the big concerns that we raised in our amicus brief, which is that over 1 million healthcare employees will potentially lose their civil rights protections at these Catholic hospitals and other religious hospitals if this test is adopted.
I was also, in listening live, and I don't know if you felt this way, but surprised at some of the answers to these questions as to teachers and other things, is that there didn't seem to be that they were always taking the route of, yes, this person's qualified as a minister, even if they did some function. So it seems like the proposal of looking at functions is as messy as any of the other proposals, which is what the teachers are offering. I think they're offering more, let's look at a more comprehensive view. And that seems to be not much different than looking at some of these functions. I just was surprised by the answers sometimes from the attorneys as to whether somebody would be a minister.
Yeah, they really kind of conjured up this de minimis religious function idea that wasn't prominently featured in their earlier briefs. But it does really raise the question of what is an important religious function. How can you decide what it is for somebody? And it really does highlight that if the court adopts this test, they may very well have painted themselves into a corner such that they will just have to defer to every religious organization who will then, from then on, only be suable when they want to be sued.
And
I think
we have
sorry. I was just going to say, I think Ruth Bader Ginsburg has said, basically who doesn't qualify as a minister, that they really are pushing this exemption so far.
Right. I think we have a final clip that maybe will lead us that way, which is what some justices are thinking. So we have a clip from Justice Gorsuch asking about some of these activities.
Counsel, I'd like to follow up on Justice Kagan's line of questioning. In response to a number of them, you indicated that you thought that the religious activities were de minimis and therefore wouldn't qualify. You're asking a secular court to make that judgment. And even when some deference is given to a religious organization in a qualified immunity sort of way or otherwise, you're still asking us to make a judgment between who qualifies as a minister and who does not, on the basis of our judgment that their activity with respect to the religion is de minimis. And I'm just wondering, does that pose some problems for you and for your clients in some of these cases. I can easily see a school in which everybody takes a pledge that everything they're going to do is to help teach these kids to be part of the faith. And churches believe, unlike some, but that every member is a minister, and not just limited to clergy. So what do we do about that? The next case is going to be a school in which a janitor takes a pledge, or the school bus driver, or the coach, and they all believe sincerely that they are ministers. And you're going to have us tell them, no, your activities are too de minimis.
Yeah, so here, this is Justice Gorsuch with pointing out how easily a religious organization can game the system under this, which is essentially goes back to the clip that you read from earlier, Patrick, showing which was another organization legally advising these religious organizations just to arbitrarily assign religious duties to everybody, so that if this religious function only test that the petitioners are asking for is adopted, then literally every employee will be covered. And that's kind of what Justice Gorsuch is wrestling with a little bit here. And that was a big part of our brief, really. We had noticed an argument that he had made in his, I believe it was in Trinity Lutheran case, and that highlighted how difficult it is to draw lines between these things. And so we really wanted to base our brief on that and really give these other justices, some conservative justices that don't vote with us as often as we'd like, something to chew on here. And we're hoping that is the case here.
And well, we should have a decision by the end of June. I don't know. This is a weird year, so I don't know if things will change. But in this case, and in the contraceptive case that I mentioned, we should have decisions coming in June. And I don't know. I'm not an optimist. It just listening to the arguments, it seems that a lot of the justices were struggling with how to handle these. So it will probably be a surprise no matter what they write. It'll be a surprise, and we'll see. What I don't think the outcome is necessarily in question. I think the teachers may well lose here, but how are they going to get there? It has a big implication for people who have jobs all across the country.
Yeah, definitely. It's really hard to say how this one will shake out, but it is hopeful that some of the votes we would need to get there are wrestling with these questions as much as they have.
Well, I would like to invite Brendan to stay with us. We are going to take questions from our viewers. And Brendan, if you have time to stay on the call, you can throw your thoughts in on some of these questions as well. So I will pull them up. And the first question is actually a good question. Eric Paul Schaffer writes, what is de minimis? And what does it mean in this context?
So de minimis in this in general just means some amount of whatever behavior we're talking about that's so small it's not really worth counting as violating the law in question. So basically they're just saying that person is barely performing a religious function and therefore it doesn't count, to put it briefly.
And it seemed that the questions, I think maybe this is where Justice Kagan was going. It's hard to define what that is, because I think she had asked at one point, if somebody's a math teacher but they say a prayer before the class, does that count as, is that de minimis, or is that teacher now a minister? So I don't think the justices could define what de minimis means, but your description certainly seems dead on in terms of what the intent behind what they mean, what the idea is behind it, but how it would imply in practice is harder to say.
Yeah, it's really the petitioners trying to install a relief valve in their argument so that they don't get pinned down to a bunch of arbitrary outcomes, which we think will happen anyways.
Right. Our next question is from Tegan Lindsay. Has FFRF ever had a case go to the U.S. Supreme Court? And the answer is yes. Patrick, do you want to talk about that a little bit?
Yeah, sure. I mean, oftentimes it's not good when one of your cases goes to the Supreme Court because it means you may be winning and they're going to overturn it. And that's what happened to FFRF in the case Hein versus Freedom from Religion Foundation in I believe it was in 2005, which the outcome was really related to standing, who can sue to challenge certain actions of the government. FFRF was continually winning a number of cases on funding for religion and faith-based initiatives, and had won. I believe they won that case at the Seventh Circuit Court of Appeals. Went to the Supreme Court, and the makeup of the court had obviously changed. I believe Justice O'Connor had taken retirement at that point in time, and so the makeup of the court changed, and the court, not surprisingly, then said FFRF didn't have standing, and kind of created a more difficult hurdle to be able to challenge funding of the government if there's not a direct, let's say, nexus between some kind of congressional bill and spending. So it's kind of a complicated or nuanced case, but that's one case that was actually taken up and decided on the merits. But we've had numerous cases where the court has been presented with the option to take, and oftentimes they've declined to take those. Even within the last 2 years, I think we have 1-2 cases where the other side had then petitioned the Supreme Court to take them, and they had the court declined to take them. But there's certainly a number of cases that FFRF's been involved in at the Supreme Court, but Hein is the one from 2005 where the court actually did take it.
And that leads us to our next question. Patrick had brought up the fact that in the last year, we did have a couple of cases where the other side appealed to the U.S. Supreme Court, hoping that they would take that case. One was our Pensacola Cross case, which the court ultimately chose not to hear arguments on, but instead remanded back down to the 11th Circuit. And the other one was a church funding case, which leads us to our next question. Tina Marie Jackson Messer says, I saw you all won your New Jersey church funding case. Do the churches have to pay the money back?
That would be great if they did. That was one potential remedy on the table when we sued over what were deemed to be historic preservation grants in New Jersey to fund in Morris County, New Jersey. Each year, it was to the tune of millions of dollars that churches were getting funding from the county to build and repair their churches. We won that case at the New Jersey Supreme Court, but the New Jersey Supreme Court said basically that program was unconstitutional, but they weren't going to order the money to be paid back. So they decided that in our favor, but the churches ended up keeping the money they got, but they no longer are able to get future funds.
And so the next question that we have is kind of a follow-up, I think, to the Hein case that we were just discussing, and really illustrates the frustration that we also sometimes have over some of these court decisions. Eric Paul Schaffer asks, why, if all the previous courts had recognized standing, was there even the option to suddenly claim that there was no standing?
I mean, Rebecca, you maybe want to weigh in on this after I do, but I mean, I think that's the Supreme Court as the final, stop can change its mind or can change the law. And so even though a number of lower courts were ruling consistently and prior Supreme Court decisions ruled one way, the court can obviously take a drastic change in approach if it wants the outcome to go that way. That may not be a satisfactory answer, but I think it's just the way that the law is actually made. Sometimes is there a majority of justices who want to change it? They can change it, and they do that from time to time, including on issues like standing.
Exactly. James Reed asks, as much as I love FFRF, I also love freedom from the government stepping on our freedoms. I could not disagree more with you urging that New Mexico sheriff to stop a church from breaking social distancing orders. Why would you take this position? That's not even a separation of church and state case. I think this is referring to a letter of complaint that we sent recently to a sheriff in New Mexico who actually went to church in uniform and took to the pulpit and actually deputized everybody in the congregation, making them sheriffs so that they would qualify as law enforcement and therefore be able to gather and be exempted from the prohibition on large gatherings. And so why would we take this position? In my view, it is not appropriate for a government official to go to a church in uniform and perform a government function of deputizing a congregation. I think that was one of the bigger problems. And it also followed on the heels of what we've been talking about earlier with the pandemic. FFRF has taken the position that governments have the right to protect public health, and these gathering restrictions protect public health and save lives. And church gatherings, unfortunately, as Patrick mentioned earlier, have led to community spread of COVID-19 and have endangered lives of many. And there are even pastors that have died. I don't know if you or Brendan have anything to tack on to that, or if you guys were familiar with that letter of complaint that went out. I think it was earlier this week or maybe at the end of last week.
I would just say, when we usually get involved is when there's some special preference going to religion or somebody abusing their authority to either advance or preference religion. And so that certainly seems to be the case here. We want the separation of state and church. And so I think oftentimes we don't want the government to be entangled in religion, but under the circumstances here, it certainly seemed that that's not what was going on.
Yeah. So the next question is from Frank Barwa. I'm interested in meeting folks who are not religious. Is there an FFRF group in the Pasadena or Los Angeles area? Well, one of the ways you can find out is by going to our website, ffrf.org, and looking at our chapter list. There is a chapter in California, they're in Sacramento. There's not an official FFRF chapter in the Los Angeles area, but I do know that there are some atheist groups there. I believe in Orange County, there is a large atheist group as well. Patrick, do you know if there are any other groups?
I don't believe
Brendan,
so, but
too.
I know our membership in the state is, I think, around 3,500 members. So there's certainly a lot of FFRF members in the Los Angeles area. If somebody wants to start a group, I think there would be plenty of people that would be interested.
Yeah. California is one of our biggest states where we get members. So there are definitely a lot of atheist, agnostics, free thinkers there. And I'm sure that there are smaller groups, but affiliated with FFRF in the Los Angeles area, unfortunately not. But like Patrick said, if there's anybody who wants to start one, that'd be great. So our last question is from Charlie Phoenix. Do you guys hire law students, and are there any openings in DC? So again, as the legal director, I can field this question. We do hire law students. In fact, we have internships every summer that are available also to out-of-state students. We have them during the academic year too, and we have externships where you can come and work during the school year for academic credit. But our internships are very wonderful. We've had a lot of students. I think we've had over 40 students in the last 11 years come to work for FFRF. Unfortunately, we are based in Madison, Wisconsin, so we don't have openings in Washington, D.C. We have a lobbyist in Washington, D.C. He's our only staff person in Washington, D.C. There's not an actual brick and mortar office in D.C. So if you want to intern for the Freedom from Religion Foundation, you would have to come to Madison, Wisconsin. Of course, we're in pandemic world right now, so everybody's working remotely. And so some of our out-of-state law students that we hired for this summer are actually going to be working remotely as well. So they're not going to be there. And that might be really big success for our internship program and allow for remote possibilities in the future. But generally, we think that to get the great experience, you really need to be in our office with our team, interacting with our attorneys, and really getting to know everybody here. So if you're interested and you're in law school, Charlie, I would definitely look at our website. We have an internship page that explains the process if you want to get a position with FFRF and really take advantage of the opportunity. I think a lot of our interns have a really great experience, and we've actually had a lot of interns stay and actually become staff attorneys at the Freedom from Religion Foundation. So that's it. That's our show. This weekend on FFRF's broadcast TV program, Free Thought Matters, FFRF co-president Dan Barker will be talking with agnostic Bible scholar Bart Ehrman. Free Thought Matters runs on stations in 12 markets, including New York City, Chicago, Los Angeles, Seattle, Houston, and others. It's also available on Facebook Live and on our YouTube channel. So please be sure to check it out. Thank you for Patrick and Brendan for joining us. And thank you for watching FFRF's Ask an Atheist. We'll be back next week. Stay safe and healthy.